So the Senzo Meyiwa murder trial has heard jaw-dropping details around the scene of the crime and how it may have been tampered with, and the existence of 2 dockets for one case. The trial was put on pause after defense lawyer Zandile Mshololo requested time to digest these revelations. Experts say that the circumstances surrounding this trial are simply unprecedented and could threaten the integrity of the state's case. Let's unpack what the way forward looks like and bring in legal analyst Mpumelelo Zikalala, who joins us now via our video link. And it's always great to have your take, sir. Thanks very much for making time. I wonder whether you envision a scenario where tomorrow the case resumes and Mshololo is not granted the time that she needs to go through the second docket because she believes that if she's not appraised of the details in this docket, it may prejudice her client.
I don't think so. The court will then say, we want to hear how far have you gone in terms of going through the docket. The one thing that she might say is to say, I haven't been given opportunity of a time to consult with my client because whatever that is there, I must be able to bounce it off my client. Let's remember the importance of the second docket and its content. You have statements that have been made under oath, of which we want to believe they're actually the truth. So if there are instances which are going to help African Mshololo's client, definitely she's going to want to test that against her client and then say to the court, there are certain documents and instances here which can be able to prove our case. However, we need more time to go through them. Can we be given an indulgence of maybe a few days before the trial then comes back? Let's remember the court will always be lenient in saying, we want you to prepare for your case adequately. In fact, it's one of the rights which are entrenched in our constitution. So that at the end of the day, if you want to table your defense, you've been given enough time, and as long as you can prove that you're not wasting any time or there are any unreasonable delays, the court is happy. But in this instance, I think if she comes back tomorrow and says, I need more time, I need to consult, this is what I've done so far, the court is definitely going to say, let's give you those few days. It may not be a long period of time, but definitely the court will serve on that indulgence.
I wonder whether, Mpumelelo, you feel that there are still answers that we need around how one case can have 2 dockets. I mean, people who work in your space have already come out to say how unprecedented this is and how, it adds complications that may actually compromise the state's case.
It does. Actually, it looks at the law enforcement agencies. How efficiently are they working? What is the communication line between the law enforcement agencies and the NPA, which at the end of the day are in charge of going to court? The reason why one would focus on that is the burden of proof which is attached to the NPA, which is guilty beyond reasonable doubt. So if there are going to be any instances of doubt which are going to be caused by the lack of proper investigation in any particular matter, one should concentrate on those ones and then say, what was so different about this case that they handled it in this particular manner? It was surprising to find the NPA saying that the second docket is news to us. We only realized it when we were here in court. Now, one would wonder what sort of preparations did they engage in? Secondly, if you are going to have a witness in the witness box who's going to dismally fail in proving the authenticity of the evidence that they found, the methodology that they've used, what type of consultation did happen took place between the NPA and that particular witness? At the end of the day, the state is well aware of its burden of proof. It's well aware of the instances of credibility and probability that they have to prove, especially when a person says, I'm an expert in this particular field. I've got the required education, training, and experience to stand in front of you and give you my expert opinion as to what actually occurred. That expert opinion covered all, backed by what I found on the scene, which I want this court to believe as being true. But most importantly, in doing all of this, you must be able to find out what the truth is, not only for the benefit of the state and the NPA, but also for the Meyiwa family, who at this stage are trying to know what actually happened on that particular day. Is there someone to blame, and then someone must be brought to book?
I mean, it's interesting you mentioned that what the NPA allegedly said. They're saying that they're not aware of the second docket. Is that even possible? I mean, given how closely the NPA ought to be working with any docket in a case where they're prosecuting?
In instances where there's in-sync communication and they've got the ultimate goal or a single goal in mind, that shouldn't be possible. But in this case, it is clear that you had 2 competing interests. You had 2 individuals or 2 entities which are not doing the job that they're supposed to do. There was lack of communication between the 2. Some may even go to say maybe there were some cover-ups which were being done, or is it just pure incompetency of the two departments or two entities? But at the end of the day, this type of instances should not occur, especially in a country that prides itself to say we have law enforcement of agencies which are non-biased, which the only intention or the interest in which they seek to serve is that of the public. But in this instance, you can see that definitely that was not done. And if the powers that be, in this case I would refer to the minister, I would refer to the commissioner, are not looking at this case and saying we want answers. We need to be provided with answers as to what actually happened to prevent this sort of thing from happening ever again. Because one would wonder, in instances where we don't have access to this particular case through the media, what happens to other cases, maybe let's say Amondo in Ghana or in any outlying area? It then means that people are not given the justice which is supposed to be guaranteed by our constitution.
Of course, what's more extraordinary about what's actually taken place here is that both dockets implicate a completely different group of people. And I mean, there isn't even overlap in terms of one of the accused. When you look at the 5 in docket number, I think it's 636, and I think it's the 7 in docket number 375. You know, I wonder what the way forward looks like, if there's going to be any kind of reconciliation of these two dockets so that there's a bit more harmony, for lack of a better term, in prosecuting this case. I mean, do you imagine a scenario where all of the accused in both dockets are now the accused in this matter?
It can be. Let's look at it this way. Firstly, the route is supposed to be traveled by in any criminal matters that the law enforcement would do the investigation, take the matter to the NPA decides. Now, in instances where the NPA has decided and there's pieces of information which have not been there, which would help to prove, most important, the motive. Why was this person killed? So that at the end of the day, we're able to prove the intention when we go to court. The NPA can then say, in reassessing these new facts that have came up to me, I'm of the view that I'm not going to only implicate the accused which are in the box now, the additional individuals that I want to harm, either for defeating the ends of justice, for not telling the truth, either for perjury if they've lied, or if there's motive that can be investigated or maybe concluded by virtue of reading the docket, then let's bring them all in so that at the end of the day, you'll be able to say, I've prosecuted the right individuals. It may be an administrative nightmare because the NPA would have to come back on Monday or during the week and say, Honorable Court, please allow us an opportunity to add additional accused. Those legal reps which are representing those legal accused, they may come and say, we are not privy to what has happened in this case before. However, we are of the view that there's only one witness that led evidence, it's only examination in chief. Allow us, Honorable Court, to do our cross-examination so that at the end of the day we can place the versions of our clients to this particular witness that is in the witness box. If at the end of the day that is achieved, that might be able to save this case from being one of the catastrophic cases that you've ever had when it comes to criminal law, or even I can put it loosely and say a travesty of justice.
Absolutely. I mean, you know, there's also real questions around how much can still be saved, given now the credibility questions that are being raised, etc. Kherinel, who of course you know is on a watching brief for some members of the Meyiwa family, believes that given the time we've already spent on this case, we haven't even gotten to a stage yet where we can link evidence to suspects, as it were. In fact, he's taken it a step further to say we spent too much time talking about the crime scene and not talking about what he believes is at the nub of this case. Who killed Senzo Meyiwa?
But you see that is important because at the end of the day, one of the things that we need to determine when giving evidence is the probability and the credibility. And in order to do that, independent forensic evidence will assist you in proving whatever motive, in linking whatever person that is there. If this particular witness would have come back and said, I took fingerprints off the door and of the kitchen counter, and they all proved to be linked to accused 1 up until accused 5. That places those particular accused in the crime scene. And then it says to them, you must be able to answer how your fingerprints landed in this particular crime scene. So which is why expert witnesses is absolutely crucial, and which is why the defense legal representatives in this case would focus on that expert witness, because they are brought in not on the basis of what they've seen on that day in terms of their own recollection. They are brought in terms of saying, in terms of your education, training, and experience, what did you find? Because you are independent in this matter, you're not going to be biased in any manner. You have no interest to protect whatsoever, either from yourselves or from your loved ones or any other friend that you may have that you don't want them to get them into trouble. So the appearance of the first witness is absolutely important so that at the end of the day, it is easy to prove that independently there's evidence that's linked to these particular witnesses. Now, if during the cross-examination, evidence links in the other individuals which are not in the witness box, it is in the best interest of the NPA to say, wait on a minute, let's go and check how this is supposed to link or how this links other individuals. Let's call them in and make them part of the co-accused. It is still early. There's only one witness which is in the witness box. When they come, there's not going to be any cries of any prejudice. Yes, it's going to be there because they would say you should have brought us in the earlier stages. However, it's not one which cannot be remedied at the end of the day. And the ultimate goal in which the NPA will then come and say, we want justice to be served in this matter. So we don't want to leave any stones unturned, and we want the ultimate truth to come out. If you allow to do this, then it's going to assist in some type of way. And at the end of the day, it's going to give the answers in which the Meyiwa family actually needs to make sure that it brings them closure to what happened on that particular day. So the case can still be saved, depending on how the NPA is going to approach the matter. It doesn't look good for them at this particular stage. I think it has shown some of the incompetence between the NPA and the law enforcement agencies, and certainly work that needs to be done in terms of training our forensic experts.
What a remarkable turn of events. Mpumelelo Zikalala, thanks for helping us connect the dots as best as you can. We'll all watch the space, of course, as that trial resumes tomorrow. Mpumelelo Zikalala, of course, is a legal analyst. Sir, once again, thanks very much indeed for your time.